court is now in session. Today, the Chamber continues to hear the testimony of witness to TCW 918. Mr. Amhoy, please report the attendance of the parties and other individuals at today's proceedings. Grazie. Mr. President, for today's proceedings, all parties to this case are present. Mr. Nuonji is present in the holding cell downstairs. He has waived his right to be present in the courtroom. The waiver has been delivered to the greffier. The witness who is to conclude his testimony today, that is to TCW 918, as well as his duty counsel, are present in the courtroom. We also have a reserved civil party to TCCP 300. Thank you. President, thank you, Mr. Amhoy. The Chamber now decides on a request by Nuonji. The Chamber has received a waiver from Nuonji dated 1st December 2015, which notes that due to his health, headache, back pain, he cannot sit or concentrate for long, and in order to effectively participate in future hearings, he requests to waive his right to participate in and be present at the 1st December 2015 hearing. Having seen the medical report of Nuonji by the duty doctor for the accused at the ECCC, dated 1st December 2015, which notes that Nuonji has dizziness when he moves and has severe back pain when he sits for long, and recommends that the Chamber grant him his request so that he can follow the proceedings remotely from the holding cell downstairs. Based on the above information and pursuant to Rule 81.5 of the ECCC internal rules, the Chamber grants Nuonji his request to follow today's proceedings remotely from the holding cell downstairs via audiovisual means. The Chamber instructs the AV unit personnel to link the proceedings to the room downstairs so that Nuonji can follow. This applies to the whole day. And before we proceed to hear the testimony of the witness, that is to TCW 918, and before the Chamber hands the floor to the co-prosecutor to put questions to the witness, the Chamber wishes to hear oral submissions regarding document E319/36, in particular in relation to paragraph 11 and 12, for additional witnesses for the proceedings of hearing the facts regarding the Vietnamese. The Chamber actually notified the parties on the 8th of November if parties wishes to respond to this submission by the International Co-Prosecutor. Then the floor will be given to the parties to make those oral submissions on the 1st December 2015, which is today. And before the floor is given to the parties, I'd like to hand the floor first to the co-prosecutor to provide some backgrounds regarding your request. And Mr. Deputy Co-International Prosecutor, you may proceed with that, so that parties can have a better understanding before the floor is given to them to make their oral submissions. You may proceed.
Thank you. Good morning, Mr. President. I understand you wish me to address first the additional Vietnamese witness that we proposed. Is that correct? Mr. President, this is a witness who we have proposed based on some additional information from him in his OCIJ interviews. While this is a witness who had a prior DC CAM statement, his DC CAM interview, which is document E305/13.23.382, had some very limited information regarding killings of Vietnamese. The entire questions from his DC CAM interview are contained in about half a page of the interview, page 13 of it. With the new interviews from this witness that were disclosed, there was some significant information on the basis of which we have proposed him as a trial witness. Primarily, in his OCIJ statements, he indicates that he firsthand witnessed 2 separate killings of Vietnamese civilians at sea and on an island. This is in his OCIJ interview E319/23.3.44, answer 25, and describes those executions that he witnessed. And equally significant, he talks about why these killings happened, which is that the regiment and battalion commanders in his division received political training, and when they returned, instructed the soldiers that the Vietnamese were considered hereditary enemies, enemy number 1, and that there were instructions to shoot and kill not just Vietnamese soldiers, but Vietnamese civilians who were fleeing and trying to escape that country. So based on that information, we believe this is a witness who provides significant evidence proving the existence of policy in the regime to target and kill Vietnamese, not just soldiers, but Vietnamese civilians. And for that reason, that is essentially why we have proposed that this person be called as a trial witness.
President, thank you, Deputy International Co-Prosecutor, for your brief request in relation to E319/36. Now I give the floor to the co-lead lawyers for civil parties. I want to know whether or not you have anything to make before the chamber in relation to E319/36 and in relation to paragraph 11 and 12. But, good morning, President and Your Honors. After reading the request and after listening to the brief explanation by the Deputy International Co-Prosecutor, the information from the Vietnamese witnesses is very important for our case file in relation to Vietnamese treatment. The information is sufficient, and co-lead lawyers have no objection to the request, and we support the request. President, thank you. Now the floor is given to the defense team for the accused, starting from the defense team for Mr. Nguyen Jia to make any responses to the request by International Co-Prosecutor. You may now proceed.
Thank you, Mr. President. Good morning, Your Honors. Although in itself I can understand the reasons for the prosecution to have this particular individual testify, there are of course also considerable problems in relation to this individual and his testimony. If my recollection is correct, I think this is the first time we speak about admitting a witness who has been interviewed not in case 4, but rather in case 3. And it seems that he is a Division 164 cadre. That brings along the question whether he is the only cadre or the only soldier or Navy person within Division 164 who has given such testimony, or whether there are any others who describe similar events. I have no idea, to be honest, at this time, how many soldiers, how many Navy personnel from Division 164 have been interviewed by the investigators. So it's very difficult to put this WRI of this particular individual in context. And of course then we arrive at the more principal problem that we have with admitting evidence coming from cases 3 and 4. We do not know, nobody knows, I think, whether he is an isolated witness testifying about this, whether there are other people within his division who have testified to similar instructions. So although I can see the potential relevance of this particular witness, we have no means to be able to evaluate or judge the broader context of his testimony. So that is again a very problematic situation, and because we cannot do that at this stage, I think we should not be hearing him as a witness within this segment, but only at a time when the investigation in case 3 is fully ended, because only then we can understand the reliability of his testimony. In addition, I would like to remark that it seems that the prosecution is only asking for 3 out of 5 WRIs. I'm not sure why that is, presumably because the other 2 WRIs do not speak about alleged killings of Vietnamese. However, we do think that they might be, that they potentially are important. So if these statements are admitted and if he is going to be summoned to testify, obviously all his WRIs should be in. And in addition, we also noted that one of the 2 DC Cam interviews that was provided is available only in Khmer, that is E3/9093. And if this witness is admitted and if his WRIs are admitted, we would urge to have that particular DC Cam interview be translated as soon as possible. But to summarize, we again arrive at a bigger problem. We do not know how this WRI was selected. We do not know if there are exculpatory, if there's exculpatory evidence saying things completely opposing this particular witness. So that's our view at this point. Thank you.
President, thank you. The floor is now given to the defense team for Mr. Kirsamport. You may now proceed.
Bonjour. Merci, Monsieur le Président.
Good morning.
Je ne surprendrai personne en disant que la...
Good morning, Mr. President. I wouldn't surprise anyone in saying that the Kirsampan defense objects to the appearance of this witness in principle, and the principle is that an investigation is for both exculpatory and inculpatory purposes, and that is why there has to be an investigation at a particular time, and that is why documents can be requested for purposes of confrontation or these documents. Today we are being asked to admit a witness whose record of interview is from another investigation. Kyo Sampan cannot really confront the documents to this witness. We object all the more so because this witness has made statements well before the end of the 002/02 investigations. And as my colleague says, I understand that this testimony interests the prosecution because it is for inculpatory purposes. But since the investigation is ongoing and we do not have the general context of the investigation, as my colleague has said, and we haven't come to the end of the investigation on this subject, we object forcefully. If this witness were to appear, we, the defense, wouldn't have sufficient materials on the basis of which to defend our client. The last point is that if you were to call this witness, whose appearance we object to, all that witness's statements must be disclosed, including his prior statements. In 2007, that witness was interviewed, and he was the subject of an application for a document to be produced in 2014. If we had had sufficient information on this witness, it would have been shared with us. The prosecution has had the opportunity to explore all the issues involved regarding this witness, and today the prosecution is telling us that those issues are important and that they were not available in the past. That is not true. That person was interviewed, and if the prosecution had wanted to obtain all the materials regarding that witness, they would have been able to do so as part of the investigations of case 002/02. That said, the tendering into evidence of the records of interview of a witness should not be done before the investigation has been completed.
Thank you. Thank you, Mr. President. Thank you, Your Honors. Good morning, everyone in and around the courtroom. I would like to raise my personal views in relation to the request to add witnesses. It is not a new matter for all of us to debate here. There are many issues to be decided and resolved. The defense has raised the objection to the request of witnesses, additional witnesses. I personally object to the request for additional witnesses because it does not give any benefit to the defense. As far as we are concerned, co-prosecutors are tasked with submitting inculpatory and exculpatory evidence. And the investigation, as we know, has completed. It is now within the trial phase. The co-prosecutors, together with the co-investigating judges, are of the view that Kyo Sampon is guilty. That is why he is sent for trial. Mr. Kyo Sampon is sent for trial. So now I observe that the co-prosecutors are required to find both exculpatory and inculpatory evidence during the investigation stage, since they are also considered the judicial police. The defense has already made a mention that it is too late. that the co-prosecutors cannot request for inculpatory evidence within this stage. The co-prosecutors, however, are required to submit exculpatory evidence instead. President, you may now proceed, Judge Vance. But first, you have the floor, International Deputy Co-Prosecutor.
Let me perhaps, because I have a question which you might wish to answer. It's a question of clarification to the international lawyer for Koh Sampang. If I understood Mr. Koppe correctly, he didn't raise any arguments based on 87.3 and 4, but pointed to the general problems with the disclosure. But I think Mrs. Giese raised an 87.4 argument by saying it was belated because there had been a previous statement in 2007. Did I get that correctly?
Pour préciser ma pensée.
To clarify my thought, Judge Vance, I am saying that we are trying to admit a new witness in this trial 002/02. Can you hear me?
I heard you until you started doing this.
So the principle is that we are being asked to admit a new witness who was not in 002/02, who was not in principle called before that date by the co-prosecutor. So I am of the view that this application is rather tardy because they should have been able to do so before. They had the means of doing so before.
Let me respond to these questions. Let me start first with the issue you've just raised. That was the gist of my initial comments. There was a 2007 interview from this witness, but it had very limited information on the Vietnamese. As I said, there's literally half a page on that, general information, nothing about firsthand information, nothing about instructions on policy. There was simply not enough. We base our decisions based on the information we have. Once an investigation is started, we do not have the right to go out and do investigations ourselves. Based on the DC Cam interview, it was not sufficient to warrant calling him as a trial witness. Based on the new information that is in his OCIJ interviews, that is the reason that we now believe he is a witness that would assist this chamber in determining the truth. It's not a question of whether it benefits the defense or benefits the prosecution either. The question is whether it benefits this chamber in ascertaining the truth on this issue. In regard to Mr. Koppe's point, we have, of course, disclosed or requested disclosure of any interviews from Division 164 cadres in Case 3 that give evidence on this subject, including if anything that would be exculpatory. We will continue to do so, obviously. So to say he's not in a position is incorrect. He has any interviews from Case 3 on this subject. If, of course, this is an ongoing investigation, we've argued this point many times. It's not reasonable for us to wait until the end of these investigations. If there are new witnesses that emerge, they will be disclosed. The defense will have the right, of course, to request witnesses that it views helpful to us. So I simply, for reasons that we've argued in the past, the principle or idea of waiting until the end of the investigation is simply not reasonable. The defense argued that it would be difficult to test the reliability of this witness's evidence until the investigation is over. I disagree. The best way to test the reliability of this witness's evidence is to bring him into court and to have all parties in the chamber question him. On the other WRIs, just so we're very clear, there are 5, I believe, in total. 3 we request. All of them have been disclosed, so there are no undisclosed interviews. 3 of them related to this subject, which is why we've moved those into evidence. And obviously, if this witness was called, we would have no objection to the other 2, though they tend to be more background and organizational related. But of course, any party would be entitled to use those interviews, and they have been disclosed. And there is only one DCCAM interview, so there is no DCCAM interview that is not translated. I think what happened is there's 2 versions of the same interview, same DCCAM interview that were put on the case file. Even though it may look like there's one that's not translated, it's the same interview. So there is a English translation of the DCCAM interview already available. I think that responds to the defense. Thank you.
President, thank you. Thank you for submissions from all parties and responses to the requests of the International Deputy Co-Prosecutor document E319/36 regarding the request to call additional witnesses, particularly concerning the Vietnamese treatment. The Chamber will take all submissions into consideration and will issue a decision in due course. Now, I hand over the floor to the co-prosecutors to put questions to TCW 918. Let me inform you that you will have only one session this morning to put questions to this witness. You may now proceed.
Excusez-moi, Monsieur le Président, juste.
Excuse me, Mr. President. I have a question for purposes of clarification. It appears to me that we also have to respond to application E317/32. I had thought that we also had to make submissions on that issue. I do not know whether this is the right time to do so. I just wanted you to confirm that today as to the way forward.
President, thank you for reminding the Chamber in relation to that document or request. The Chamber has not contemplated the responses to the document E319/23, said the President. Third, 23 or 32, I'm not quite sure. On 32, Mr. President. President, thank you. The Chamber will inform parties concerning the matter after the break time. The Chamber will then inform the parties when it is the appropriate time for you parties to make responses to the document E319/32. Now the Chamber gives the floor to... You have the floor now, Kope.
Thank you, Mr. President. That's something in relation to this witness. I should have raised it yesterday, but I hope it's still in time. In one of his WRIs, E39567, the witness refers to various photographs or his own photographs, and he's being shown by the investigator 5 photos. We have searched for these photos, but we don't have them, and we were wondering whether the prosecution maybe has these photos, and if yes, whether the prosecution would be willing to make these photos available to the defense.
Mr. President, someone in our office is hopefully watching this. I'll have them check on the status of that. I'm not sure whether or not those photos that were attachments were disclosed. I have seen them. They're not what you might hope to be based on that, but nonetheless, I'd like you to be able to see that yourselves. So, if someone from our office is listening, I'll have them check that and see if they haven't been disclosed, see if there should be no problem in having these photographs, but we'll need to ask the investigating judge for that.
President, thank you. Now we resume the questioning of witness.
Thank you, Mr. President. And good morning, Mr. Witness. I want to, this morning, ask you some questions about the purge of your region, that is specifically about arrests of local Northwest Zone or Sector 5 cadres that took place in the 1977 to 78 time period. And I want to start by trying to clarify the timing of when these events began. Do you remember, Mr. Witness, what month it was that Taval, Sector Chief Tahung, and Prenet Pre District Secretary Tamung were arrested? Do you remember what month and year that was?
Witness. Good morning, Mr. President. Let me inform you regarding the arrests of cadres, some cadres. Some of them I have known their names. My chief, who was my chief, Tabal, was arrested during the transplanting season, perhaps in June or July. I know that he was arrested in the transplanting season. He was arrested at night. As for other cadres, I understand that they were also arrested. However, I do not know when they were arrested. I noticed their disappearance after I heard that they were arrested.
Thank you, Mr. Witness. To help your recollection, there are some S-21 records that establish the dates on which these cadres were arrested and sent to the S-21 security office in Phnom Penh. Before I get to those records, though, I wanted to ask you in regards to Taval. Do you remember Taval's original name, the name that he used other than his alias Val?
Answer. Concerning his original name, it was Horn. I do not know whether it was his original or actual name. He was called Horn. However, his revolutionary name was Val.
Mr. President, at this time I'd like to provide to the witness document E3/9646, E3/9646. It is an S-21 list of prisoners who entered on the 28th of June, 1977. I'd like to ask him about two of the people on that list who are people he has mentioned.
Yes, you may proceed.
Mr. Witness, this is a record from S-21 of prisoners who entered on a single day, the 28th of June, 1977. Numbers 25 to 48 on the list are cadres from the Northwest Zone, primarily Sector 5, your region. And if you could direct your attention to number 29 on the list, I've highlighted the numbers. You'll find them on the second page, if you look at the second page of the document. Number 29 is Ok Hon, alias Val, 39 years old, identified as assistant for dam construction and fertilizer production. And number 34 on the list, a few numbers down, is An Mong, a secretary of Prey Net Prey district. Does that refresh your recollection, Mr. Witness, that it was in June 1977 that both Taval and Ta Mong were arrested?
It was in July. However, on this document, there is a person named Mao and Uk Lin or En, and I cannot see the name of Val on this document.
You need to look at number 29, Mr. Witness, and you need to look. There's one column that has his family name, Ok Hon, and then there's a second column that has his alias, where you'll see the alias Val. So you need to look at two different places on the document. while you're doing that, the record indicates that Taval was about 39 years old in 1977. That would have made him about 8 or 9 years older than you. Is that consistent with your recollection, Mr. Witness? Do you remember how much older Taval was than you?
Yeah.
Yes, he was older than me, but I do not know his real age.
Mr. Witness, do you remember what month it was that the cadres from the Southwest Zone arrived in your region?
I cannot recall the exact period the Southwest group arrived. It was in 1977, and it could be in July or August. And before their arrival, there was another group of cadres from the West Zone.
Tell us a little bit about those cadres from the West Zone. What did they do when they arrived? Did they assume leadership positions like the Southwest cadres, or did they have some other function?
I do not know about any cadres coming from the East Zone.
My question may not have come across right, but I'm talking about the West Zone cadres that you just mentioned. The cadres from the West Zone, what can you tell us about what they did when they arrived in your region? Did the West Zone cadres assume leadership positions like the Southwest cadres did when they arrived?
Cadres from the West Zone were of the middle age, and they came together with their families, that is wives and children, and they were placed in various communes. However, they did not involved with the force at the sector level. They were integrated into the commune and the cooperative mobile units.
In regards to the timing of the arrival of the Southwest cadres, M. Chem, who you have identified as a Southwest cadre who replaced Prey District Secretary Mung, she has told DC Cam that she arrived in the district before Mung was taken away. Specifically, Your Honors, I'm referring to document E3 5657, E3 5657, which was a March 2007 DC Cam interview of M. Chem at Khmer page 00061-325, English 00089-773, French 00347-356, where M. Chem stated, quote, "Upon my arrival, Ta Mung and Ta At," referring to Mung's deputy, still survived. But after I got the list, both of them were taken away. End of quote. So Im Chem has said that she was in Prey District before Tamang's arrest, which we know was in late June of 1977. In June 1977, Mr. Witness, were you still working at Trapiang Tama Dam, or had you been transferred to the sector fishing unit at that time?
By that time, I had been reassigned from the Trapiang Tama Dam worksite to the fishing unit to provide the supply through the workers at the Trapiang Tama Dam worksite. However, my unit remained the same, although I have been assigned or reassigned to the fishing unit.
During the time you were with the fishing unit, how much time did you spend out at the rivers or areas where the fishing was being conducted by your workers? And how much time did you come back to Trapiang Tama or to the sector or district offices? Can you give us some sense of where you spent your time after you became part of the sector fishing unit?
I was with the fishing unit for about 10 days. Then I transported the fish or the fermented fish to the mobile unit forces at the Trapiang Tama work site. However, it varied. Sometimes I had to spend like 1.5 months at the fishing unit before we could transport the food supply to the sector mobile unit forces. So it varied between a fortnight to 6 weeks. Or sometimes it happened within a week if we could find fish.
When the cadres in your region were arrested, were there just a few cadres who were arrested and who disappeared? Or did many of the sector, the Northwest cadres from your region, were many of them arrested and disappeared?
Regarding their disappearance, I personally was through and witnessed the disappearance of my immediate supervisor. Cadres at the district or the communes also disappeared, but I did not know of their circumstances or whether they were arrested at during the day or at night time.
I want to ask you about a statement you made in your DC CAM interview, E3 9094. This excerpt is at Khmer ERN 00734 097 through 98, English 00728 689, French 0112 3649 through 50. You said the following, quote, and you were describing a meeting you had with the new sector chief, Ta Rin. Quote, I went to meet Ta Rin. He said that, now, if you do not believe me, you can look at the list of arrested names. There are only 2 names not in the arrest list. They are you and Tayuk. And then you said, the rest would be arrested. I saw all the names. End of quote. In this meeting that you described with Sector Chief Taurin, you said that there were only two cadres sector cadres whose names were not on the list of those to be arrested. Yourself and a person you identified as Ta Yuk. Can you tell us who Ta Yuk was?
The name was not Jew. In fact, the proper pronunciation is